At this time, I'm going to yield to Mr. Rooney, who chairs our NSA Cyber Committee, for questions.
Thank you, Mr. Chairman. I'd like to direct my questions first and foremost to Admiral Rogers to convey my thanks to the many men and women for their dedication at the NSA for keeping our country safe, as well as I want to talk about the recent media stories that may have led to confusion in the public about what the NSA is and is not legally collecting and the safeguards the NSA has put into place to protect personal data. So I'd like to clarify, as the chairman of the subcommittee on the NSA, I recently got to meet your deputy admiral last week out at the NSA, and we visited and spoke some of these things. And what we can talk about here today publicly, if you could go into, if you can't, you can't. But I think that it's important for the people in the room and listening outside understand. Is it true that the NSA would need a court order based on probable cause to conduct electronic surveillance on a U.S. person inside the United States?
Yes, sir.
And just to be clear, the section of the FISA that is expiring later this year, that's 702, which we'll be talking about a little bit, cannot be used to target U.S. persons or persons in the United States. Is that correct?
Yes, sir.
Section 702 focuses on non-U.S. persons outside the United States primarily, correct?
Yes, sir.
Do you believe that the Section 702 is important and valuable for U.S. national security?
Yes, sir.
So it's safe to say that without having this tool, it would be a threat to our national security.
It would significantly impact my ability to generate the insights that I believe this nation needs.
In the media, there's a lot of reporting about something called incidental collection. Can you talk about what incidental collection is?
Yes, sir. Incidental collection is when we are targeting a valid foreign target, for example, and in the course of that targeting, we either get a reference to a U.S. person or suddenly a U.S. person appears as part of the conversation. That's what we call incidental collecting.
And what do you do when something like that happens? If there's a U.S. person part of an incidental collection, what kind of safeguards are put in place to make sure that?
So it depends specifically on the legal authority that we're using to execute the collection in the first place, but in broad terms, realizing again, it varies a little bit by the specific authority that we're using to conduct the collection. We step back and we ask ourselves first, are we dealing with a U.S. person here? Is there something that we didn't expect to encounter that we've now encountered? We'll ask ourselves what leads us to believe that it is a person. If we come to the conclusion that it is a U.S. person, then we ask ourselves, are we listening to criminal activity? Are we seeing something of imminent threat or danger, for example? Or are we just receiving something that has nothing to do with any of our valid collection authority? Based on that, we'll then take a series of actions. In some case, we will just purge the collect. Make no reporting on it, not retain the data. It's incidental collection. It has no intelligence value, and it wasn't the purpose of what we were doing. In some cases, then, if we believe that there is intelligence value, for example, whether it's a reference to a U.S. person, as an example in a scenario, in our reporting, then we will mask the identity of the individual. We'll use a phrase like U.S. person 1 or U.S. person 2. And I would remind everyone that for our purposes, U.S. person is defined very broadly. That is not just a U.S. citizen. That is a U.S. corporation. That is a ship or aircraft that is registered in the United States. That is an internet protocol address, for example. So it's not just a particular individual, if that makes sense. The term for us is much broader because it's designed to ensure our protections of U.S. persons.
And those, the procedures and protections you talked about are required and approved by the FISA court, is that correct?
Yes, sir, and the Attorney General.
And you mentioned in your opening statement that for that kind of information to be disseminated outside of your agency in the NSA, that dissemination would be strictly on a need-to-know basis. Is that correct?
We use two criteria. Is there a need to know in the course of the person or group that is asking for the identification? Is there a valid need to know in the course of the execution of their official duties? So,
who would that be?
It could be another element with the intelligence community. It could be another element within NSA. It could be a military customer, for example, who's reading some of our reporting. It could be a policymaker. I apologize. There was one other point that I wanted to make, but I've lost the thread in my mind. I apologize. If I jump in a moment, I'll try to make it.
Let's get back to masking briefly. You spoke about masking and trying to keep a U.S. Person's identity concealed. And when it is disseminated, we often talk about in the intelligence community about the exceptions to if somebody's masks, how you unmask them. What would the exceptions to that masking be before it's disseminated?
So again, we use two criteria: the need to know on the person requesting us and the execution of their official duties, and the second part was, is the identification necessary to truly understand the context and the intelligence value that the report is designed to generate? Those are the two criteria we use.
Is that identity of a U.S. person communicating with a foreign target, is that ordinarily disseminated in a masked or unmasked form?
No, it is normally disseminated. If we make the decision that there's intelligence value and we're going to report on it, it is normally disseminated in a masked form. I would, again, as I said, we'll use a reference, U.S. Person 1, U.S. Person 2. I would highlight, if you look at the total breadth of our reporting involving U.S. persons at all is an incredibly small subset, in my experience, of our total reporting.
Who normally in the NSA would make the decision to unmask?
There are 20 individuals, including myself, who I have delegated this authority to approve unmasked requests.
And does the level of approval change depending on the reason for unmasking? If it was something or somebody, say, really important, would that matter? Or could it be?
It's not necessarily in writing that way, certainly by custom and tradition. At times, requests will be pushed up to on the senior most of the 20 individuals. Requests will be pushed to my level saying, hey, sir, we just want to make sure that you're comfortable with this.
So 20 people, what procedures or safeguards are put in place to make sure that those 20 people are not unmasking wrongly?
So they retrieve specific training. There are specific controls put in place in terms of our ability to disseminate information out of the databases associated with U.S. persons.
Okay, let's run through the exceptions quickly through a following hypothetical. If the NSA collects a communication where a target under surveillance is talking to a U.S. person, how would the NSA determine whether disseminating the U.S. person information is necessary to understanding the foreign intelligence or assess its importance?
So first, we'll try to understand the nature of the conversation. Is this truly something that involves intelligence or a national security implication for the United States, or is this just very normal, reasonable conversations, in which case we have no desire to have any awareness of it? It's not applicable to our mission. And I said in that case, normally we'll purge the data. We'll ask ourselves, is there criminal activity involved? Is there potential threat or harm to U.S. individuals being discussed in the conversation, for example?
If there was criminal activity involved, what would you do then?
If we decide if it's criminal activity, we'll disseminate the information. If the FBI or other criminal activities are on the reporting stream, in some cases, I also will generate a signed letter under my signature in specific cases to Department of Justice, highlighting that what we think we have is potential criminal activity, but because we are not a law enforcement or justice organization, we're not in a place to make that determination.
Okay, based on that, again, hypothetically, if the NSA obtained the communication of Flynn while he was communicating with a surveillance target legally, would you please explain how General Flynn's identity could be unmasked based on the exceptions that we discussed?
Sir, I'm not going to discuss even hypotheticals about individuals. I'm sorry.
If I could make reference to a Washington Post article that I have here from February 9th, which states, let me say what it is and I'll ask if you've read it or if you've seen it, which states national security under Michael Flynn privately discussed U.S. sanctions against Russia with the country's ambassador to the United States during the month before President Trump took office, contrary to public assertions by Trump officials. Current and former U.S. officials said. The article goes on to say that 9 current or former officials who were in senior positions at multiple agencies at the time of the call spoke under the condition of anonymity to discuss intelligence matters. Did you read this article?
I apologize, sir. It's not an article that references 9 particular individuals. It doesn't necessarily ring a bell. I've certainly seen plenty of media reporting to that, but again, I'm not going to comment on specifics.
Just basically, under the breadth of that article, when we hear that 9 former current officials had spoken to the press under the condition of anonymity, and we heard Director Comey and the chairman speak of this as a potential crime, a serious crime under the Espionage Act. Assuming if this article is accurate, who would be in a position to request the unmasking of General Flynn's identity? Would that be you?
I would have the authority to do that.
Who else would?
Other individuals.
Would that include Director Comey?
I'm talking about
in the NSA alone,
within the National Security Agency, and we're talking about NSA reporting.
But would people like Director Comey also be able to request that?
Yes.
And the Attorney General and Director Clapper, are those type of people also on this list?
Again, I'm not going to talk. In general, yes, they would be
generally
able to come
speaking,
and ask.
not with regard.
Be able to come and ask. Not going to talk about the specifics of an individual or hypothetical scenarios.
Well, here's what I'm trying to get at. If what we're talking about is a serious crime, as has been alleged, in your opinion, would leaking of a U.S. person who has been unmasked and disseminated by intelligence community officials, would that leaking to the press hurt or help our ability to conduct national security matters? Okay, if it hurts, so this leak, which through the 702 tool, which we all agree is vital, or you and I at least agree to that, do you think that that leak actually threatens our national security? If it's a crime, and if it's unveiling a masked person, and this tool is so important that it could potentially jeopardize this tool when we have to try to reauthorize it in a few months. If this is used against the ability of us to reauthorize this tool, and we can't get it done because whoever did this leak, or these 9 people that did this leak, create such a stir, whether it be in our legislative process or whatever, that they don't feel confident that a U.S. person under the 702 program can be masked successfully and not leak to the press. Doesn't that leak hurt our national security?
Yes, sir.
Can you think of any reason why somebody would want to leak the identity of a masked person?
No, sir. I mean, I have raised this directly with my own workforce over the course of the last few months to remind everyone part of the ethics of our profession, not just the legal requirement, but the ethics of our profession as intelligence professionals, is we do not engage in this activity. And I've also reminded the men and women of the National Security Agency, if I become aware of any such conduct, there is no place for you on this team. It's unacceptable to citizens of the nation.
Well, I think that, as we move forward, obviously, I think that what you're speaking of is this sacred trust that the intelligence community has with the American people and with the people that are representing them here on this dais. And I think that it's vital that for those who break that sacred trust, if they are not held accountable, whether it by the NSA internally or by the FBI through conviction or investigation / prosecution and / conviction through the Attorney General's office of that crime, it is very difficult for us to be able to keep that sacred trust, to know that what we're doing is valid and what we're doing has no nefarious motivations, and to us to be able to keep America safe without violating the constitutional protections that we all enjoy. Mr. Chairman, I'm not sure how much more time I have left. I just wanted to
Congressman, can I make one comment if I could? I apologize. It comes to my mind based on your question. I just want to remind everyone that in general, FISA collection on targets in the United States has nothing to do with 702. I just want to make sure we're not confusing the two things here. 702 is collection overseas against non-U.S. persons.
Right, and what we're talking about here is incidentally, if a U.S. person is talking to a foreign person that we're listening to, whether or not that person is unmasked.
I just want to make sure we understand the context, that's all.
And whether or not somebody in the intelligence community that we put the trust in is going to leak that information to the press for whatever reason. And I'm not even going to get into the gratuitous, what that reason may be. But it's really going to hurt the people on this committee and you all in the intelligence community when we try to retain this tool this year and trying to convince some of our colleagues that this is really important for national security. When somebody in the intelligence community says, you know what, the hell with it. I'm going to release this person's name because I'm going to get something out of it. We're all going to be hurt by that if we can't reauthorize this tool. Do you agree with that?
Yes, sir.
Mr. Chairman, do I have enough time to talk about the letter that the committee sent? The committee sent to you on March 15th a letter to Admiral Rogers and to Director Comey. Have you had a chance to look at this letter? I think that you've actually...
Yes, sir. I, in fact, have given you a reply on the 17th.
Just real quickly, because I don't want to take up any more time, can you give us a sense of how many unmasked U.S. persons' identities were disseminated by the NSA from June 2016 to June 2017?
No, sir. As I have indicated, we're in the process of compiling that information. I will provide it to the committee, but until that work is done, I am not going to comment.
Can you tell us whether any of those disseminations broadly were involved U.S. people relating to presidential candidates Donald J. Trump or Hillary Clinton and their associates in 2016?
I won't answer until I complete the research, sir.
Assuming that the NSA disseminated unmasked U.S. persons' information relating to the Trump or Clinton campaigns, would that have been a reason for such unmasking?
I apologize. I don't truly understand the question.
Let me just move on to the next one.
All right.
Along those lines, if the NSA had wanted to disseminate unmasked U.S. persons' information related to either the presidential campaign, who in the NSA would have approved such disseminations?
Again, it would have been one of the 20, and I provided that in my initial response to the committee. I've outlined the procedures. I've outlined the specific 20 individuals.
Thank you, Admiral. I appreciate your answers. I look forward to working with you on the subcommittee moving forward. And, Mr. Chairman, I yield back.
Gentleman yields